NZ Dr. Learned Counsel for the petitioner. Dismissed as withdrawn.
One more item, my lord. Item 16, my lord. She is seeking time for the NCB, my lord. Can it be on next week, my lord?
Of Learned Counsel for NCB list the matter. Next week, I think, is holiday.
Next week, any date, my lord? I'm obliged.
May I please your lordship? I beg to mention item 65. So I want to do my lord. Petitioner will file in child portal.
5, yes. As withdrawn in prayer of Swens.
Since case is charge sheeted, my lord. I am obliged for this.
65, you said. 65.
65 then. Case is charge sheeted, my lord. He will file in child court, my lord.
The beg to mention item 41, my lord. Case there has not come. I have been informed, my lord.
Item 41, CD not received.
Interim order shall continue, my lord.
41.
Yes, my lord. Interim order shall continue, my lord.
Obliged.
I beg to mention item number 26.
Hmm.
We are filing objection to the lordship, kindly fix.
26. Learned Counsel for P. The side. List the matter again on.
Lordship, can it be 22, lordship?
May I please, lordship? My lord, victim item number 17, my lord. Here, my lord, the victim statement has not been recorded, my lord. The victim statement, my lord, has not been recorded before the court below, my lord. The next date is 28th, my lord. Can it be on 38th, my lord, along with the up-to-date case record?
Item?
17, my lord.
Give the date.
On 30th of January, with the up-to-date case record, my lord.
Counsel for petitioner list. Up-to-date, not along with, first use the up-to-date case diary on that said date.
Again, similar brief item 25, my lord. Here also victim statement not recorded, my lord.
25.
Yes, my lord. Next
Okay,
date is 2nd of February, my lord. Can it be on 5th, my lord?
55 TCR not yet received, my lord.
5th of February.
Along with the up-to-date TCR. Obliged, sir. Higher up.
My pleasure, Worship, I beg to mention for listing this interlocutory application for correction of.
Correction.
If today, your lordship, if possible. Today,
Today, tomorrow.
tomorrow, oblige, your lordship.
Please, your lordship. I beg to mention item number 24, lordship. Maybe adjourn for today, lordship. Maybe fix on 19 of this month.
Learned Counsel. 19.
Obliged.
Your lordship, I beg to mention an anticipatory bill application for listing, your lordship. After tomorrow, your lordship.
Rejected by me earlier.
Your lordship, because court number 8 is not sitting, your lordship. For that reason, then special acts is there, your lordship.
Is there only one other criminal bench?
But their lordship bail application, not special acts, your lordship. This court only had the acts for the.
And tomorrow.
After tomorrow, your lordship.
Day after tomorrow.
After tomorrow, lordship. Much obliged, lordship.
Item number 46, my lord. Case there has not been received, my lord.
CD not received. List
Interim
again.
is there, my lord.
46.
Yes, my lord. Interim is there, my lord. Interim may continue.
The next date of.
On 29/1.
Obliged, my lord.
May I please, lordship? On item number 52, my lord, it become impulse suspend. The petitioner is being arrested, my lord. 52.
Submitted that the case has become infructuous due to arrest of the petitioner. Hence dismissed as in.
May I please, your lordship? Lordship, I beg to mention item number 38. Up to date CD is not been missing.
Date up to date CD not received. List again on.
Interim order will continue.
Interim order passed earlier to date of listing.
10 copy, my lord, not case diary, LCR received, my lord.
10 copy received.
Received.
TCR received, my lord, not CD, my lord.
What do we want now? Your lordship may adjourn it, no problem, but saying that, my lord, CD not received.
FSL.
Trial court record. Only TCR is received without the CD. No, my lord, already search sheeted case TCR received. There is no question. No, separately, somehow the CD may be left behind, so that is what, but everything is here now. Everything. This was item
38.
38. The CD not received, colon on prayer of learned council. The date.
Obliged.
Wait, please, your lordship. I beg to mention item number 60. Today we are going to file our affidavit. So kindly fix the
60. 60.
60, yes.
Counsel for the petition adjournment as affidavit is going to be filed today. Is the matter again on?
May it please your lordship, I beg to mention item number 43. Most surely C is not there, the matter may be adjourned. Item number 43.
Received list again.
Continue, your lordship.
Interim order passed 32.
On 28/1.
Deeply obliged.
May it please your lordship. Lordship, I beg to mention item number 18, my lord. My lord, adds on that day, my lord.
18 on the prayer
Matter
of learned
can
counsel.
21, my lord.
The matter again on.
18 of 21. Yes.
Yes, next.
Hello.
May it please your lordship. The item number 45, lordship, anticipatory bail matter, lordship. I have the instruction the charge sheet is submitted, lordship. The petitioner is not on interim bail. Lordship, we will approach the court below, lordship. The allegation is rape is there.
Item number
45. I have the CS number, lordship.
Number 45. It is submitted on behalf of the petitioner that charge sheet by CS number so and so has already
207,
been submitted.
2025. 207. 2025.
It is submitted that the petitioner will approach the learned below. Regular bail.
Dated 2/12,
Accordingly.
2025.
This instant
12.
petition stands closed.
Obliged.
Lordship, I beg to mention item number 56 petition, my lord. Counsel with the other setting, my lord. Matter may will be passed over for the day, my lord.
Item number
57.
657.
57. Prayer of learned counsel. Passed over for the day. Have you taken consent of other side?
Yes, my lord.
The consent of other side. Is the matter again on?
Obliged, my lord.
Yeah, please, Your Honor, sorry. Item number 60, actually my senior 29th January out of station, so February 1st date. 60.
Already adjourned, give a date. Change February date. Date to February lage tahato. Then
1st February,
will not be there.
2nd February. Thanks, Your Honor.
May please, lordship. I have the instruction to withdraw this petition.
The prayer of learned counsel for the people is dismissed as withdrawn.
Obliged, lordship. Wait, please, your lordship. CD may be called for lordship.
Already. Call for the city. List again on.
On my lord, 2nd of February.
Obliged. And same, lordship.
All right, same.
Obliged. Please, Lordship. We have been in the jail since 2025, Lordship. In NDPS case, it is supposed to be over the mandatory period on 28th January this month, Lord.
28.
This month, 20 तारीख, 20. Also, considering the detention period, may be allowed to go on bail. So the section 27A was there. So nothing was recovered, money or all those things, Lord.
Sometime I will have to get the instruction regarding filing of the search sheet. 27A is there, my lord, regarding earlier rejection order. He is involved in trafficking of drugs. Trial court rejection order, page 15. Relevant portion is page 15.
We have not, we have disclosed everything, Lords, before this. We are praying for on detention, Lords, the period of detention. Let him get instruction, Lords. I don't have objection. At 2, Lordship. Deep tablets.
May please, Lordship, my lord. May please for the up-to-date TCR we call for, my lord. Rejected by Lordship.
Did TCR be called for? This again on. On 4th of February.
Obliged, highly obliged.
Appears call for the CD. Third of February, 3-2.
May I please, Lordship? Here in this case, date of arrest is on 2/11/2025. However, Your Lordship, the accused in this case was in judicial custody much prior to the lodging of the FIR. He was in judicial custody in NI case, Lordship, since 25/5/2019, Lordship.
So in this case, how many days?
In this case, 66 days, Lordship. And his name is not there in the FIR.
What are the sections involved?
Lordship?
Sections?
Sections are 18 of UAP, Lordship, and 5 of explosive. But here, as per the allegation given in the forwarding, Your Lordship.
Still, we have to see the CD. It's 90 days, isn't it?
Lordship.
Yes, well, otherwise, well, I will also have to go to through 2 of the court judgments of the coordinate benches. While my lord, UAPA is also section 18 is also there. That my lord, that UAPA falls under my lord schedule of the NIA offenses, well, under NIA. So whether this petition is maintainable before the single bench or the division bench regarding that.
Lordship,
aspect
as per
also.
the allegation, Lordship,
It will-
there was some conversation, SMS, but throughout he was in jail only, Lordship. How can that be possible, Lordship?
Your lordship may call for the case diary, my lord. All right.
Always, Lordship.
It-
Lordship.
Kindly pass over for time being.
May I please, your lordship? My lord, 483 application, my lord. Offence under section 13 subclause 1 of Assam Cattle Preservation Act, my lord. FIR at page 14, my lord. In this case, allegation is that the petitioners are slaughtering a cow, my lord, and the police apprehended and recovered the meat, my lord, of 86 kgs, my lord. My lord, kindly may peruse that page, my lord. Is my petition, my lord. Para number 6, my lord. Para number 6, my lord. My please, dear, my lord. Actually, what happened, my lord? I have a grandson, my lord. and he was born on 2012, my lord. And as per Islamic religion, my lord, after the birth of a child, my lord, the akika is given, my lord. Akika means the sacrifice of any animal, my lord. And on that purpose, my lord, the grandfather, he is the petitioner before your lordship. He hoped to sacrifice that bull, my lord. He has his domestic bull, my lord, old bull, and to hope to distribute the meat among the neighbors and a portion of meat to cook and for call for his family members for dinner, my lord. And in the morning time, my lord, at that time, the police recovered the meat and raid his house, my lord. And this is he is not the professional slaughterer, my lord. He cut his domestic bull, my lord, for that purpose, only akika for, my lord. I am behind the bar for 25 days, my lord. This is true, and my lord,
Page 22 of the trial court rejection order, relevant portion is from third line, page 22. Observation on the trial. 56 kgs.
yes, it is one bull, my lord. One bull was cut, my lord. About 86 or 90 kgs among this meat found, my lord. And the meat were recovered and already, my lord, disposed of, my lord, as per court's order, my lord. And I am behind there for 25 days, my lord. I will cooperate with the investigation, my lord. Otherwise, I am not the professional slaughterer, my lord. Whatever the consequence of the trial, I will face, my lord. At his own home, my lord.
Third learned counsel for the petitioner, learned additional 50. This is an application under so and so. The application is there are three. On behalf of the petitioner, slaughtered his own bull, domestic bull, for religious purposes. Same was distributed among family members and not intended for sale. It has been seized and disposed of pursuant to caused by the examination. The petitioner has spent 25 days in custody. During the care of the allegations, the custodial detention of the petitioner not be necessary. Accordingly, the prayer for bail is allowed. 20,000 one surety. Cooperate with the investigation.
Chief Judicial Magistrate, Kamrup, Metro, my lord. Highly obliged.
If the charge sheeted matter under NDPS Act, the TCR may be got.
It is submitted that CS has already been submitted, hence call for the scan copy of the TCR along with CD. 5-2.
Please, Your Lordship. Regular bail application, Lordship. Petitioner is behind the bar for last 38 days. Section 6 of the POCSO Act is there, Lordship. CD would be required, Lordship. And notice to the informant, Lordship.
Yes.
28, Lordship. Obvious.
Charge sheeted case, Lordship, prevention of
Hmm?
prevention of crimes, that's an act, Lordship. 85 days behind the bar.
Yes.
Can we
we-
call for Lordship?
Lordship, we need 2 weeks' time to file our reply in this matter.
Lordship, a short date may be given, Lordship. Petitioner's father has expired, Lordship.
2 weeks, they will again seek date otherwise. Third learned counsel for the petitioner. Standing counsel CBI seeks 2 weeks time to file reply. Accordingly, list the matter again on so and so. In the meantime, the objection proc reply be positively filed by the CBI. Further, the case diary will also be.
Regular bail application under that, Lordship. Petitioner is behind the bar for 25 days, Lordship, and he is not named in the FIR. So it may be given on 9.
Commercial quantity of the control.
Lordship, nothing has been seized from her position, Lordship.
Are seated.
No, Lordship. Please. Can it be 19, Lordship?
19.
19, my lord, already many other cases. 21 would be approved.
No, but if it is 85 days,
25 days, man.
Huh?
25 days.
25 days.
25 days.
All right. CD list again on. You did it.
My legal Lordship. My lord, this is a charge sheeted matter. My lord, as per secret information, police, my lord, recovered 10 bottles of cough syrup with codeine elements, my lord. And according to them, my lord, it was commercial quantity, my lord. Page 18, my lord, FIR, my lord, and relevant portion, page 19, my lord. 19, here specifically it is stated in the FIR, then 10 numbers of plastic cough syrup, my lord, in the middle, my lord. Accordingly, my lord, this pharmacist, my lord, the owner of the pharmacy was arrested. Then, my lord, he, my lord, preferred one bail application before this honorable court, my lord. And this honorable court, my lord, found that, my lord, this is not, my lord, commercial quantity, my lord, because there is no material to show that, my lord, without, my lord, plastic bottle, liquid portion is, my lord, amount to commercial quantity. Therefore, my lord, with finding and referring to other judgment, my lord, bail was granted, my lord. Just I beg to, my lord, show before your lordship the relevant portion of this bail granting order, page 34, my lord.
34.
34, my lord. I am just showing, my lord, relevant portion. 34, my lord, paragraph 12, my lord. On perusal of materials available in TCR, this court could not find any materials or document to show that actually the seized materials was weighted, excluding the plastic container bottles, to come to a findings that the materials which were seized is of commercial quantity. That being so, and taking into account the ratio laid down in the case of Hari Singh Supra, this court is of the considered view that at this stage, the benefit of doubt should be given to the accused applicant for granting bail at this stage. Accordingly, my lord, this main owner of the pharmacy was granted bail. My lord. This humble petitioner before your lordship is the my lord ex my lord helper in this pharmacy, my lord, and he filed my lord one anticipatory bail application before the learned my lord session judge, and his bail application was declined, my lord, page 36. It was stated that, my lord, at this stage it is not necessary because, my lord, case is charge sheeted. There is no apprehension of his arrest, my lord, and my lord, short order was passed, my lord, page 36, annexure 5, my lord. It is, my lord, I beg to state, my lord.
Wait, just a moment. Let us. Who are you?
My lord, I am, my lord, ex, my lord, worker of this pharmacy, my lord. His, my lord, bail, pre-arrest bail application page 36 was, my lord, declined. At this stage, my lord, though it was charge sheeted, that it is charge sheeted, there is no apprehension of arrest. Like that, my lord, it was rejected. When, my lord, he received notice, my lord, page 38, my lord, annexure 6, my lord, recently this petitioner before your lordship received notice of this case, my lord, because trial is, my lord, began, my lord. And after receiving, my lord, this notice, and as per earlier order passed by the learned session judge, my lord, he filed, my lord, this pre-arrest, another pre-arrest bail application before the learned session judge, page 39, my lord, annexure 7. Here, my lord,
Still, we have to call for the TCR because
Yes.
commercial, rightly or wrongly, commercial quantity is involved. So, without looking at the, how can we allow?
only, my lord, thing is that, my lord, after, my lord, hearing and, my lord, considering the materials on record, my lord, this honorable court, my lord, prima facie, my lord, satisfied that, my lord, there is no materials on record to show this is a commercial.
It was at that time, it may be there now. Let us see them.
My lord, learned session just said that, my lord, this his pre-arrest bail application was not maintainable before the
After filing of charge sheet.
tax return. In this regard, I have submitted one judgment of the honorable Supreme Court. my
Call
lord.
for the charge sheet has been submitted in the case by CS number. Yeah.
But,
Call for the scan copy of the TCR. Just again, no?
But 29 days. 29
Oblige, I am giving card number. Oblige.
Hey, please, your lordship.
Lordship, this is against the non-compliance of the order passed by the learned Eleka Magistrate under 175(3) of the BNSS. That is why I am before your Lordship by the officer in charge of the Dispur PS. The order is at page 20, Annexure 3. I'm reading the relevant portion of the order. Upon hearing the learned counsel for the
Page?
petitioner,
This is WPC criminal, my lord. I will have to inform the government advocate. My government.
at this stage, notice may go. Because once there is an order under 175(3), it is the duty of the police officer in charge to register the case. Because that was passed by regional order has been passed. And that is at page 20, Annexure 3. Notice may be issued at this stage, then
What is the case about? Otherwise,
Lordship, this is against some misappropriation of, sorry, Lordship, this is against the senior IS officer misusing his position has registered a plot of land which was in his name without any doing any formalities, such as the sale or gift from his wife. That is the basic allegation.
I would not like to take up this matter because certain reasons. Please listen before another bench. I work together with the person closely, so there may be allegations. Please the matter before another bench without me.
My lord, I'm sorry to interrupt, Lordship. Hold on. My lord, in item number 5, I could not appear, Lordship, due to this.
You are not going back anywhere now.
But Lordship is showing it in non-appearance. Lordship already fixed a date on 3rd of February, Lordship.
None appears to be said.
Lordship, oblige, Lordship.
May I please, my lord? Well, this is the requisition criminal, my lord, filed under Article 226, my lord, and read with Section 528 BNSS, my lord. Here, my lord, what happened, my lord? A incident was took place in the mill of the petitioner, my lord, where, my lord, a minor boy, my lord, his finger was cut off, my lord. May I, my lord?
Just a moment. Rice mill was seized.
Initially, it was sealed, my lord. Then it subsequently seized or not categorically stated, but the magistrate presumed that it was seized. Initially,
Inform government advocate.
they also file affidavit, also filed, my lord. Today, my lord,
So what is required to be done today?
can be disposed of, my lord, today.
Huh?
Or can be disposed of, my lord.
For that will need government advocate.
My lord, after some time, my lord.
Inform.
This is also WPC criminal.
Lordship,
Matter, I'm appealing for the transport department. We have filed our affidavit, my lord. The has been blacklisted as per a FIR. So the blacklist cannot be removed by the transport department unless an NOC is given by the police station from the police, my lord.
any order maybe passed, Lordship, because the vehicle has been lying since 2022. It is almost more than 3 years, Your Lordship. It will be damaged, Your Lordship.
Vehicle has been released.
But it is unlocked in the official website.
What is the meaning of that? Unlock in the official website.
My lord,
means what?
there's a portal, once the police communicates to the DTO that there's an FIR and the case is pending regarding that vehicle, so the vehicle should not be transacted. So that to prevent that, the police has written to us, and thereafter we have blacklisted so that it cannot be transacted upon. Thereafter, my lord, I think the directions has been given to the police. Communicate that there is no objection on their part. Vehicle can be released. There is no other pending anything else as well.
Then we need government advocate to obtain instructions for that.
Hello. The nodal agents from that.
Whether PP can obtain instruction in this regard regarding no objection from police for unlocking the portal. Who is representing police? So this is a matter of seizure of a vehicle.
In police station.
A vehicle was seized in connection with a
yes,
case,
yes.
police case, is it not?
Yes, ma'am. I will get the.
Subsequently, it was released by order of the court. But the official website is still blocked and the transport department says they cannot unblock it without no objection from the police. So we'll get instruction from the police in this regard.
Yes, ma'am. Can get the instruction, my lord, from the police.
All right.
Copy of that order may kindly be served.
Which order? Today's?
Yes.
Had learned counsel for the petitioner. Yes. And also had learned counsel representing transport department. It appears that the vehicle in question has already been released, but the official website has not yet been unlocked. And petitioner is unable to renew the documents of the said vehicle due to blockage of the website. There it is submitted on behalf of Transport Department that the website can be unblocked only upon receipt of notice from the concerned police station. Concerned IO. Okay. Hence, learned additional PP directed to obtain instructions from the IO. Which case, any case number is mentioned? Biswanath Seriali, IO of Biswanath Seriali, yes, case number 67 of 22. As to whether NOC has been issued, and if not, if there is any impediment in issuing the NOC. List the matter again on. TCR was called for, received. Before, my lord. Yes, TCR received. None appears for the petitioner. TCR has been received. List the matter again. Date.
May I please your lordship. Lordship, 483 application lordship, charge sheeted matter lordship. So case lordship. Lordship, 258 days behind the bars. Only problem is lordship.
Vehicle, he's the not on owner of that vehicle, my lord. Can you have a look the FIR at page 13, my lord?
CD is received. CD not received. IO is directed to produce the CD positively on the next date fixed. List the matter again on.
My lord, 21. Keep your list.
My lord, this is charge sheeted case, my lord. POXO is there, my lord. My lord, the trial is going to be concluded, my lord. A short date may given, my lord. Trial is going to be concluded. Trial is going to be concluded. Very good. We'll have it after 3 months then. My lord, out of 9 witnesses, my lord, 6 or 7 are examined, my lord. Service report on respondent number 2 is not yet complete. Wait, list again on. 21, my lord. Obliged, my lord. May I please, your lordship? My lord, this is a charge sheeted case.
Here is also my lord.
The lordship 50 days behind the bar. Same order. 21st. District court just call for you. This means that a grievous hurt was there, Your Lordship. Same and complainant was already being examined, Your Lordship. The victim is my elder brother, Your Lordship. Ceremony was going on and it is after taking alcohol that some injury was there. 131 days behind the bar, Your Lordship. And charge sheet, translate copy at please print you. Okay. Single injury. Hard Mr. Spencer. LPP.
Information is the victims about.
This is an application under the allegation against the petitioner is that he had assaulted the victim on the head with a dowel. Arising because of an altercation. Subsequently, charge sheet has been filed in the case and trial has commenced and the victim and the informant has already been examined by the learned trial court. And in the meantime, the petitioner has spent how many days?
131 days.
31 days behind bars. For medical report, the is a single injury to the head of the victim is grievous in nature. Having regard to the aforesaid facts, period of detention, further detention of the petitioner not warranted accordingly. Therefore, bail is allowed. 50,000 one surety. Inspection of the learned trial court is for that the prisoner shall not try to influence the witnesses, regularly participate in the trial, disposed of accordingly.
Obliged, sir.
Your lordship, will the item be passed for the time being? Senior is late.
Not received. Have it on 21st. The matter again on 21st.
Made, please, your lordship. Your lordship, it was registered as NTP intermediate quantity, but the sampling order reflect that it's a small quantity and 94 days behind the bar, your lordship. Charge sheet has been
Yes, sir.
94 days behind the bar, your lordship. And page number.
Where is the seizure list?
Seizure list page number 22, your lordship. Page number 22 and 23. Only 4 vials were recovered, and along with the plastic containers, with the plastic packet for sampling, 0.70 grams. And these are the 4, page number 23, S1, S2, S3, S4, your lordship. Which comes down roughly around 1 gram, your lordship. Small quantity, your lordship. 27A was there, and therefore the allegation was with regards to financing. Item number 32, petitioner is an 18 years old boy, your lordship, 94 days behind the bars. Kindly some.
No, if it is small quantity, then the statutory period
is over.
But when was charge sheet submitted? Where is the FIR?
FIR, your lordship, is at page number 13, your lordship, for 11, your lordship, FIR. There is no allegation against petitioner number 32, and 31 was arrested not without any narcotic substance. Paragraph number, page number 11, your lordship. May I read the FIR?
Lordship, may kindly come to page number 15, Your Lordship. Page number 15, 27A allegation is clear, Your Lordship. Page number 15. Item number 30 and 31. In page number 15, from the top, Your Lordship, third paragraph. As per the information of Saleh Ahmed, Abdul Hannan and Moinuddin are involved in the financing of illicit trafficking of NDPS or providing funds, Your Lordship. In any manner, Your Lordship, against Saleh Ahmed, that is petitioner number in item number 31, there is no allegation of 27A. From his statement, 27A has been attracted against Moinuddin, Your Lordship. And he's just 18 years old boy, Your Lordship, who was used by this person, if allegations are correct, to any extent, Your Lordship. And he's not involved in any manner, Your Lordship. At least for petitioner number 31, Your Lordship.
This is in respect of Moinuddin, 30.
This is 30 and 31 is clubbed together, Your Lordship. This is with regards to item number 31. Saleh Ahmed is petitioner in item number 31, Your Lordship.
No, we are dealing with 30
and
now.
31, oh, yeah, 30, Your Lordship.
We are dealing with 30.
In
Okay.
30, the co-accused statement implicated 27A, Your Lordship. This is the only line against which 27A was attracted. No monetary transaction was recovered, no money was recovered, nothing was seized, Your Lordship. And he was apprehended from a different location, not even from the location of the crime scene, Your Lordship.
It is there. As it's submitted. TCR is there. No. Hmm?
Your Lordship may have a mercy on item on the 18 years old boy, Your Lordship. 18 years old, Your Lordship. And 27A only is attracted against him, not involved. Financing is against Moinuddin, Your Lordship, not against Saleh Ahmed, Your Lordship. Your Lordship. I'm also agreeing with that submission, Your Lordship, because Saleh Ahmed's statement says that Moinuddin is involved, Your Lordship. Saleh Ahmed is the 18-year-old boy who is used by this person. If we go by the allegation, Your Lordship, he is not under 27A, Your Lordship.
Information. All of them involved in the last parameter, 30 minutes. As per information. From Saleh Ahmed. But information Saleh Ahmed. All of them involved.
We need to look at that information.
From
We'll see. Because nothing was recovered from Moinuddin.
But from Saleh Ahmed is small quantity recovery, Your Lordship.
then the records of
The length of detention and age of the petitioner, Your Lordship, 4 days behind the bar, Your Lordship.
Okay, let's see. 31 chamber.
Deeply obliged, Your Lordship.
My apologies, my lord. In the earlier matter, your lordship has fixed it on 21st. Statutory period will be over on that. 20th, my lord, if possible. Is there? I'm deeply aware.
Please, your lordship.
My lord, 483 will application, my lord, the FIR is at page 14, my lord. Allegation, my lord, the was arrested on 13/11, my lord, he is behind the bar for 56 days, man. Already, my lord, mobile phone and SIM card was also, my lord, recovered at page 16, my lord. The forwarding report, my lord, at para 3, my lord. In course of investigation, the mobile phone along with the SIM card has been recovered and seized from the possession of the accused person.
I think we had earlier granted bail in similar cases.
Yes, my lord. Within 11 days, your lordship has, my lord, granted bail.
Our learned counsel for the petitioner, learned LPP. An application under Suen's allegation against the petitioner as reflected in the FIR that he made some objectionable comments Facebook connection with the bomb blast near Red Fort in Delhi. The investigation is charge sheet has already been submitted and the petitioner has been in detention for 6 days. Considering the nature of the allegations and the fact that charge sheet has already been submitted by CS number further detention of the petitioner warranted. 50,000 to securities.
Please, your lordship. Regular bail application under 483, my lord. My lord, I was arrested on 11th of November 2025.
It call for charge sheet has already been submitted by CS number. So and also call for the scanned copy of the TCR along with C.
Okay. 2nd February, man. Deeply obliged.
May I please, your lordship? This matter relates to under section 6 of POCSO Act. Petitioner was arrested on
That's why, my lord, I am praying that I do not know what is the status of the case, whether it has been charge sheeted or not. Charge sheeted. Status to case. Can go back to my CD.
TCR is here.
From other person, those who are occupants of the vehicle.
mobile was seized from the keys from the statement of the arresting person. The consignment for was seized from the for anticipated to surrender before the proportion of now started at that point.
So, sorry, Mr. Biswas.
That,
You take your chance there.
but it is a fact that whether I will get the Tufan Singh's protection, Tufan Singh's case protection I will get. Go with your statement that I was there also.
And
to
besides
deliver
that, there are other materials.
Yes. I am praying for on medical ground, madam. Nothing is there. It is a fact that
On
recovery
medical
was
ground,
there
you can
from the
pray
vehicle,
before the trial court
in
action.
which
But first you appear there.
I was also traveling.
What is your medical ground now?
He is yet to be recovered, madam. I have given the picture, madam, page 20. Kindly peruse the 22, 23 page, madam. He's still resides, my lord, not recovered, my lord. He had been to Patna and other places also.
On that ground alone, you will remain at large. There's only a fracture there on the leg. It's 32. Paragraph 7. Court by order dated in AB 19. That here is bail application. Material available in the CD. considered to be a fit case for grant of arrest bail. I view right. Been submitted. The present petitioner hasn't. Yep. There is a.
May I please, Your Honor. Let pre-arrest bail application, my lord. I am on interim, my lord. I have already appeared before the IO, my lord. And my statement has already been recorded, my lord. FIR lordship will find page 15.
Did they receive? For some time.
Lordship, I am appearing in item number 39.
Yes.
I am grateful for your Lordship for allowing me to appear online, my lords. My lords, I have already appeared before the IO. I am on an interim. The FIR is of in page 10, and the FIR is of 2020. It was registered as Rangia PS case, and later on it was transferred to the CID Ulubari. Subsequent to that, in the year 2025, a 41A notice was issued, my lords. That is at page 25. Based on that, I was granted interim bail, my lords, and I appeared before the IO. So my interim may be, my lords, made absolute.
Received.
Cyber fraud, my lord. Amount.
If I may assist on merits, my lords, the FIR is at page 10. If your lordship may kindly come to page 10.
Kindly fill that statement.
The FIR was lodged in the year 2020, my lords. I'll just read through the FIR, my lords.
Yeah, I've already gone through it. Let
Ah.
us see what is the statement. New statement, what does it say?
Of them went to the.
May I request?
It is already charge sheeted now.
Not charge sheet. My lord, here is earlier it was Rongia case, my lord. It was registered under Rongia, my lord. Thereafter it was handed over to the CID, my lord.
No, what is it that I am reading here? CS number 2.
My lord, it is earlier, my lord, earlier case, my lord, Rongia, my lord, Rongia case. Thereafter it was transferred to the, my lord, CID.
This will take some time to read this.
My
But
lord,
anyway.
but sufficient, I was collected sufficient material against him also, my lord.
May I just add just two things, my lords?
Yes.
So FIR was registered in 2020. Based on that, 5 people were arrested. This is nothing has to do with the cyber fraud. It has to do, as per the FIR, in ATM, from ATM, some money was being taken account fraudulently. Based on that, 5 people were arrested who were given bail by this honorable court. Malats. The order is at page 23. In one of the accused who happened to be my brother, my younger brother, accused number 4. Now, after this FIR, subsequently in the year 2025, they transfer this FIR to the CID, and CID issues me a 41A notice. Malats. I am ready to, I am an uneducated person, illiterate person, Malats. Even to have some sort of how ATM functions, I need to have some basic education, Malats. If that is the case, that it's a cyber fraud, Malats. So A, Malats. And B, I am ready to face the trial, and I have already appeared before IO. And there is nothing on material, as far as my understanding, Malats, that incriminate me in any way. So that will be my humble submission. Otherwise, Malats, if we all the is 7 years, there is only cheating for 420, and all the others are Malats, around 3 years. So Malats, it may be made up absolute, Malats.
My objection may be recorded.
Much obliged, Your Lords.
Item 40 also similar prayer, my lord.
What is the similar prayer?
After some time.
My lord, here is CD not received, my lord. CD not received, my lord.
When?
My lord, huh? 30, my lord, 30.
Hello, I would much obliged, Your Lordship.
Forty-four.
Yes, 44.
My lord. My lord, here perhaps this year was called for, my lord. This is a office note, my lord. Item 44. It is a complaint case, my lord.
Earlier occasion, Lordship has granted interim bail to the petitioners and they have accordingly appeared before the trial court below.
As per office note, TCR not yet received, issue reminder list again on so and so. Interim order passed earlier to continue.
My lord, in the month of February, my lord. 4th of February.
Sorry, my lord, I was not there on time, my lord. Couldn't I go? Oh, CBSE. Here, my lord, with all respect, my lord.
There was earlier rejection.
My lord.
Earlier rejection is there.
AB.
AB was rejected, my lord. So that is why, my lord, it went to the court which rejected the AB, my lord. But court was of the, my lord, the decent opinion that as I rejected the AB, it should not come to me, doesn't make any difference because now it is bail. So many days in custody, hence it was sent back, as I have understood. My lord. Yeah, my lord, BA was never rejected, my lord. Here, my lord, the bribe giver, with all respect, my lord, he is already on bail, my lord. But bribe taker, he is inside, my lord. And this man, my lord, neither bribe giving nor bribe taking, my lord. In the conspiracy part or whatever be it, my lord, those sections of law are there, my lord. If it is a partnership firm or a company, my lord. Now, my lord, with all respect, my lord, coming to the FIR, I'll be very cryptic, my lord. It occurs at page 19, my lord. And he is there already there for page 19, my lord.
Yes.
If read in totality, my lord, with all respect, my lord, the first page 19, so far as I am concerned, these last 4 lines would be applicable, my lord. And as an unknown others, not named, my lord, unknown others with intention to obtain illegal gratification for favorable grant of the extension of time. There are, my lord, if work is pending, the work pending would be that extension of time, my lord. And my lord, with all respect, my lord, issuance of completion certificate, my lord. But those were, the record speaks, my lord, those were already complete, my lord. And here what has happened, my lord, CBI has told 2 stories together, my lord, regarding bribe taking and bribe giving, my lord. One is caught red-handed, my lord. The other is that he was waiting in the premises, my lord. And hence, my lord, taking that dichotomy into account, my lord, the bribe giver was granted the privilege of bail, my lord. That I'll come, my lord. Here, my lord, if any work was pending, that has to be as regards, my lord, to obtain, my lord, for favorable grant of extension of time. An extension of time regarding, my lord, peculiar situation, my lord. Only 4 kilometers, petty amount is left, my lord, with all respect, my lord, because of some land dispute with the landowners. Have I made my position clear, my lord? And, my lord, issuance of completion certificate, my lord. That this is the case. And, my lord, this gentleman is, I'm not saying he cannot be a gentleman, he is inside, my lord. The accused here, my lord, with all respect, I would be submitting, my lord. He is neither the bribe giver nor the bribe keeper, but your in the management of the firm in question, my lord, if I read in totality. And that bribe was to be paid, that was page 20. The date is very important, Your Honor. First paragraph, second paragraph, third paragraph. Sources further reveal that on 10-10-25. This is of importance possibly. 10-10-25. His date, it was decided. Thereafter, Your Honor, with all respect, that everything was complete. I had come to straight away to page 119. Page 119. This is the minutes of a meeting, and this is dated 3-10-25. Prior hand, it was decided, Your Honor. Oh, I'm sorry, Your Lordships. Page 119, dated 3-10-25, and it relates to minutes of meeting conveyed under the chairmanship of so-and-so, dated 37-25, much earlier. Please find the enclosed herewith the minutes of the meeting. And the minutes are as such, with all respect, Lordships, that occurs at page 123. 123, exactly at the end. The part of job which we are entrusted to carry out construction, this is this part, Demo Moran National Highway. Lordship may have found, and towards the right, I am reading it in totality. Dibrugarh informed the progress of the period is 99.40%. That percent of job is already done. And balance work includes construction of service road in 400-meter length, which is affected due to unavailability of land. Have I made my position clear, my lord? If I read in totality, which is proposed to be dealing for construction during DLP, the proposal shall immediately be initiated for seeking kind approval. So this part was left. Thereafter, I turned the page. Again, comment part, testing of completed work is in progress and proposal for issuance of completion certificate shall be submitted shortly. the chair instructed to expedite testing and issuance of completion certificate by 31/8/25. So regarding completion certificate, with all respect, no job was pending for giving bribe, possibly, your lordships. And regarding extension, that cannot be carried out by any official by taking bribe. The land clearance has to come, some litigation or something possibly, as I have understood. Because in plain and simple English, for what reason I do not know. If I read it in earlier paragraph, your lordships. GMP Dibrugarh informed that progress of the project is 99.40% and balance work includes construction of service road 400-meter land, which is affected due to unavailability of land, for whatever be it. So land cannot be made available by any official by taking bribe. Regarding the remaining person, and regarding clearance, completion certificate, that has already been directed to be released, completion certificate. This is their charge sheet that I have stated before you, lordships. And thereafter, may I come to a telephonic conversation. This man who is behind bars for 29 days, he even doesn't know the bribe taker. This is apparent from their document and phone tapping allegedly made, of course, by following the due process of law, that occurs at page 54.
Yes.
Page 54, my lord. Last paragraph. Analysis of this conversation, lordship may not have found.
54.
54, my lord. My lord, lordship may have found, my lord. With all respect, my lord. Analysis of this conversation reveals critical insight into the modus operandi of the accused. In particular, recorded exchanges dated 17/9/25 so-and-so and 25/9/25 between Sri Maniram Riten Kumar Singh, the bribe taker, and Sri Binod Kumar Jain, the bribe giver, who is already on bail. I'll read that, my lord. Indicate that Sri Riten Kumar Singh repeatedly pressurized Binod Kumar Jain, the bribe giver, to meet him in person, including during late hours. This is very important, my lord. In a conversation dated 23/9/25 between Sri Amit Jain, the person who is inside and for whom we are seeking bail, is there for 29 days, and Sri Binod Kumar Jain, my employee, the bribe giver, my lord, bribe giver. Sri Binod Kumar Jain stated, Binod Kumar Jain means the person who is on bail and who is the bribe giver, my lord. Uska phone aaya tha, meaning thereby the bribe taker, my lord. Usko 10 dene ka hai. When asked by Sri Amit Jain, then Amit Jain asked why this money is needed. Kisko? Lordship has seen, my lord. Phone conversation between my employee and myself, the bribe giver. Kisko? Sri Binod Kumar Jain replied, Kumar ko. Even there is no telephonic conversation between me and the bribe taker. And I was not even aware, my lord, these words are very palpable, my lord. When asked by Sri Amit Jain, Kisko, means to whom bribe is to be paid. This much, my lord. And thereafter, why? The bribe giver was given the privilege of bail. Lordship may kindly have a look at page 75. This is the memorandum of recovery, my lord, page 75. I'm reading the relevant portion, my lord. Lordship may have found 75, my lord. First paragraph, second paragraph, third paragraph. On reaching the office second floor, it was found that the chamber of Sri Manish Riten Kumar Singh, the bride taker, my lord. ED and RO is situated on the right side of the reception. When the CBI team moved towards the chamber of Manish Ram Riten Kumar Singh, ED RO, the middle-aged person who has alighted from the car was seen coming out of the chamber. He was given introduction, self and independence. This is the language, my lord, by Abhimanyu Kumar PI by displaying their identity card, and on being asked, he introduced himself as Sri Vinod Kumar Jain, partner Mrs. Mohanlal Jain, a partnership firm having its office in so-and-so, 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 goes on and on. Thereafter, on being challenged that he has just handed over the bribe amount to Manish Ram Singh, NRO, he became perplexed and did not utter any word. Meaning thereby, if this paragraph is read, he was a rank outsider giving bribe, and that he was caught red-handed is absolutely out of question, my lord. Their own story, my lord. This paragraph. He was meaning thereby he was outside office. Normally, in a case like this, Lordship knows more than me, my lord. We also little bit, my lord, that there is a shadow witness who follows. Those things are not here. Here, my lord, the bribe giver was arrested in the premises, but that red-handed part catching him is absolutely out of question, my lord. And the bail order by which the bribe giver was granted the privilege of bail, it is made apparent. If I read that order, my lord, I'll be reading it hereafter, my lord. And thereafter, the other part of the CBI story occurs at page 84, my lord. Now here they tell a different story, my lord. Exactly the last part, my lord, C. Lordship may have found, my lord. With all respect, my lord. Sri Vinod Kumar Jain, Representative Mr. Mohanlal Jain, a company associated with the construction of National Highway under Dibrugarh Project Management, so-and-so, was caught red-handed. Was caught red-handed. Two different versions, but the same prosecuting agency, my lord. Red-handed, my lord. Now I come to, my lord, with all respect, my lord, the bail order that occurs at page 100. This has been elaborately discussed and have hence granted the privilege of bail, my lord, page 100. The relevant portion, my lord, that occurs at, leaving aside some lines from the top, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from down below, my lord. Page 100, 10th line from down below, my lord. This sequence of events elaborately discussed, and thereafter bail has been granted to the bribe giver, my lord. And there is no telephonic conversation between the bribe taker and myself, my lord, but only between the bribe giver and myself, my lord. And there also I ask to whom it is to be paid. These lines read as under of the bail order, my lord. Therefore, these two versions of the CBI do not say the same thing, and therefore it cannot be prima facie ascertained at this stage as to which version of the CBI story is correct, whether caught red-handed or whether he was in the premises but not caught red-handed. In case of trap relating to bribery, sequence of events is of utmost importance, and there should not be any missing link relating to demand and acceptance of bribery. In the instant case, after perusal of the materials, this court prima facie could not find any substantive material which reveals that the accused applicant was in fact found at the time of delivering the alleged amount of bribery to the co-accused. Hence, my lord, thereafter, he was granted the privilege of bail, my lord, that occurs at the next page, my lord. 101, my lord. He was allowed to go on a bail of rupees with 1 lakh with para 19, my lord. Because of this dichotomy, my lord, with all respect, my lord. And here, my lord, with all respect, my lord, initially during some period of time, my lord, if demand itself is there, my lord, disjunctive, my lord, demand and acceptance, my lord, or rather I'll disjunctive or, my lord. If one was present, that was good enough, my lord. Then, my lord, there were, my lord, different authorities of the apex court saying different things, my lord. Ultimately, it was referred, my lord. That decision also I have brought, my lord. I'll place it subsequently, my lord. There it has been clear. Your lordship knows more than me, my lord, that demand and acceptance, those are to be in conjunction and not or, my lord. Here, my lord, kindly see, my lord, I do not know. When there are two views of the CBI, hence bail has been granted, then acceptance is totally gone, my lord. When acceptance is gone, let them do any amount of, my lord, further in the interrogation, further investigation, whatever be it, my lord, with all respect, my lord. But they would never be able to prove the acceptance part of it, my lord. Because the authority, because it will be an Article 141 authority, my lord. Demand and acceptance. Acceptance, when it goes, no matter of, my lord, investigation, by digging further deeper into, nothing can come out, my lord. But ultimately, in my humble understanding as a student of law, my lord, there cannot be any other situation that can be visualized at the end of trial, save and accept acquittal, my lord. Even to the extent of discharge at the time of framing of charge, my lord. This is my understanding, my lord. I may be wrong, open to modification, my lord. And why this accused was arrested, that is of paramount importance, my lord. That, my lord, with all respect, my lord, they say I was absconding. Absconding means I prefer pre-arrest bail application, my lord. I prefer pre-arrest bail application, my lord. Honorable Court rejected it, my lord. And upon rejection, I get a earlier 41A, my 35(3) notice, my lord. Upon receipt of notice, I immediately appeared, my lord. That chronologically, I'll place it before your lordships, my lord. And second part, my lord, why I have been arrested, I'll also read that, my lord. That although I appeared, I did not implicate myself, my lord. That is violative of Article 23, my lord. That I'm coming, my lord, with all respect, my lord, kindly see. And after, my lord, with all respect, my lord, after being remanded to judicial custody, two things have happened. Whether my further custodial, my lord, detention is necessary, my lord. I was sent to jail, judicial custody. Not a single day CBI has interrogated me in jail, my lord. Secondly, my office was sealed. Office was sealed in Calcutta. Meanwhile, it has been, my lord, with all respect, my lord, recharged, and, my lord, the office has been opened, my lord. That I'll come, my lord, with all respect, my lord. Lordship would kindly bear with me, my lord. My lord, Lordship would kindly have a look at page 28, why I was arrested. Page 27, my lord. Page 27. Lordship may kindly have a look at page 27 of our application, which we have annexed, my lord. Second paragraph, my lord. Lordship may have found, my lord. It further states that the accused Amit Jain was absconding after registration of case and moved the Honorable Guwahati High Court, praying for grant of anticipatory bail. My lord, this is, my lord, when a, my lord, statutory provision is there, constitutional mandate is there, if one moves pre-arrest bail and remains away from police, if that is absconding, my lord, at least some language correction is necessary, my lord, with all respect, my lord. The tenor is not good enough, my lord. I was never, definitely not absconding, my lord. That is one part of it. Thereafter, my lord, with all respect and folded hands, my lord, may I come to page 30, my lord. Page 30. Accused of, lordship may have found, my lord, page 30. Accused Amit Jain has appeared before CBI, ACB in compliance of notice. This is after rejection, my lord. When High Court rejected my application, I was served with a notice under section 35(3). BNS has issued on 3/12, and accordingly he has been examined and interrogated. But during interrogation, he did not cooperate with the investigation and continuously gave evasive reply. That he was told to say that he conspired in arranging that bribe, my lord. I'm not to implicate myself, my lord. And that I need not read out, my lord. Article 23, my lord. He cannot be a witness against himself, my lord. There's a constitutional mandate, my lord. At least this semblance of, I should not say, my lord. At least in black and white, this has come, my lord. The reason of arrest is twofold, my lord. I absconded, which is contrary to truth. Secondly, I did not implicate myself. I did not become a witness against myself in consonance with Article 23, my lord. For these two reasons, I was arrested. And after being sent to judicial custody, I have never been interrogated. Those two things I am placing, my lord. Never been interrogated. And my office was searched. It's a Calcutta-based firm, my lord.
No, but page 31, second last paragraph says, court deems it appropriate to allow the CBI to take accused Amit Jain for 5 days police
He was
custody.
taken. First, he was taken, my lord. When arrested, my lord, the police custody is a norm, my lord. Police custody was sought for. It was granted. Thereafter, it ended. He was remanded back to judicial custody. After being remanded back to judicial custody, if they want me in custody, my lord, for custodial interrogation, I'm not meaning police custodial interrogation, my lord, in judicial custody, my lord. Father, that was never carried out. 5 days, I was definitely, my lord, that it is in my favor, my lord, that I was granted 5 days police custody, despite the facts and circumstances of the case, my lord, mechanically. I went through the rigors of being interrogated during police custody. Thereafter, I was remanded to police custody. In police custody for a single day, even for a single day, even for a single moment, no CBI official came, or even nobody came to interrogate me, my lord. So like a gunny bag, I have been kept there, my lord. And meanwhile, my lord, my house was searched. My house was searched. An office memo, we have could not annex it with the bail application, my lord. We got it subsequently, my lord. I'm reading it and placing it before your lordships, my lord. আমার কোন তারিখে arrest হয়েছিল?
10-12
My lord, I was arrested on 10/12 and this search was made while I was in judicial, I was in judicial custody on 22/12/25. Lordship, I have seen the date and hour of search. Towards the left, my lord. Right, our name is there, my lord. Amit Jain. Lordship, I have found, my lord. Third, my lord. Third, my lord. Towards the left, date and hour of search 22/12/25, 19:30 hours. And thereafter, my lord, 4, name and address of the person whose house office is searched, Amit Jain. And thereafter, my lord, I turned the page, next page, it is there, my lord. Accordingly, Sri Aman Jain and Sanjay Biswas came to the above mentioned residential premises where it was de-sealed. Lordship may have found, my lord. Residential premises where it was de-sealed with the key which was bought by so and so, my lord. Lordship has seen, my lord.
Yes.
It has been de-sealed. Only some documents were sealed. It was, my lord, initially it was kept under lock and key. Lock and key has been removed, my lord. And I am in judicial custody, not a single day of interrogation, my lord. And my lord, 4, charge sheet 4, my lord, the date and hour of charge, chronologically 3. Towards the right, it is 4. Name and address of the person whose house office is searched, official premises of Sri Amit Jain, Messrs. So and so. And on that day, it was, my lord, de-sealed. Anybody can enter and anybody can come out, my lord. That rigors are gone, my lord. Thereafter, my lord, with all respect, my lord, এটা কোনটো পঢ়ি আছিলো আমি 100 কৰিলো নহয় now lordship may with all respect and fold the hands, my lord, lordship may kindly have a look at page 103. That I was absconding, that is totally, my lord, not in consonance with fact. Lordship may kindly have a look at 103. Day 10 hour of search. 14, 10, 25, 10, 30 are first day, no?
Oh, yes, first day, on the day.
First day. On the date of lodging of affair, my lord, that I was not absconding. What they write, and what is the actual factual metric different? 103, day 10 hour of search, 14, 10, 25, first date of charge, my lord. Thereafter, my lord. My lord, kindly see towards the right 4, name and address of the person whose house is searched, Amit Jain, that he was physically present, remarks. In pursuance of search warrant as enclosed by so and so, goes on and on. Shown, identify and search warrant and told purpose of search. After he, within bracket Amit Jain, provided free ingress and search. Lordship has seen, my lord.
Reading from which one now? Right now?
103, my lord.
103.
At that time, I am reading this to put emphasis that no absconding. Total cooperation, my lord. Even after rejection, I received 35 free notice and I appeared and arrested. 5 days police custody thereafter. Then judicial custody, no interrogation. Lordship may have found, my lord. Told purpose of search, after he, within bracket Amit Jain, provided free, I allowed free and allowed the search to take place. Have I made my position clear, my lord? So what they write, I was arrested for abscondence because I was seeking bail away from them. My presence is ascertained. And secondly, my lord, with all respect, my lord, I did not implicate myself. Huh? And my lord, the rejection of AB order, why it was rejected, that also I am reading out, my lord. That occurs at page 115. That only parameters were different, and had he been in custody, possibly bail would have been granted. Possibly, my lord, that is my understanding and tenor, the language and tenor of the judgment. Page 115. It was rejected for discounts, my lord. Upon lordship may have found, my lord.
Yes.
Rejection of pre-arrest bail of the accused, my lord. Upon perusing the aforesaid judgment rendered by the Honorable Supreme Court, where Supreme Court was quoted, my lord, perhaps the following principles relevant in the case can be ruled out. The power of granting anticipated bail stands on a different footing from that of regular bail. Exactly, my lord, because regular bail meaning thereby the bribe giver was granted the privilege of bail. 2. The custodial examination has its own significance. Custodial interrogation is necessary. Custodial interrogation, 5 days police custody, my lord. Thereafter in jail, no interrogation thereafter, my lord. 3. In certain situation, examination of an accused under a cover of anticipated bail may not be so effective. So effective interrogation took place. I was arrested. Then 4. With regard to serious offences and financial crimes, the threshold for granting anticipated bail would be higher. Exactly. But my lord, kindly see why I am saying. This is, of course, not drawing a parallel, my lord. Here, white collar crime, huge economic offense, quantum is 10 lakhs. Have I made my position clear, my lord? Whereas, the 2G scam, my lord, 1 crore 76 lakhs. And ultimately, why drawing a parallel, my lord? Discharge at the time of freeing by the Tisazari court, my lord. So bugle blows, my lord, but the sounds reverberates, but ultimately it dies down, my lord. Why I'm saying, my lord, here they always say it's a huge economic crime. Yes, compared to that 1,76,000 crore, it is 10 lakh rupees. Recovered, and that too, 2 different versions, my lord. Caught red-handed, not caught red-handed. He was there in the premises. On that count itself, my lord, the case will go, I'll face the authorities, my lord. When there is no conviction, ultimately, my lord, one a man be there. And neither he is the bribe giver, nor he is the bribe taker, my lord. And thereafter, my lord, with all respect, my lord, lordship will kindly have a look at page 118. This is the 35-3 notice, my lord. Let me put the facts straight. 118, my lord. So and so, my lord, it was served on 3/12/25 that I am to appear on 10/12/25. This is after rejection of the pre-arrest bail. I got this, I appeared, my lord. To pay schema. 1-1. I appeared, my lord. Then AB rejection, I read out, my lord, with all respect, my lord. In judicial custody, I have never been, like a gunny bag, I have been kept, I have never been interrogated. Charge split, I have read out, my lord. Now, my lord, 2-3, if necessary, my lord, I'll just place it, my lord, that demand and acceptance on, kindly see, my lord, in a case, when first of all, my lord, section 7, then thereafter the other section should come. Partnership, my lord, being in management, there is a section of law. If section 7 fails, I'm a student of law, my lord. What would be the outcome, my lord? The bail order itself and the sequence of events I have stated, my lord. Caught red-handed, and thereafter, my lord, he was there in the premises, not caught red-handed, meaning thereby 7 goes. When 7 goes, so what would the other, can somebody be after trial, be convicted, even if they dig further more into it, my lord, bring out further evidence, my lord, tons of evidence. Can the other sections of law would be applicable? That management, hand in glove with the bride giver committed offenses, because 7 has no food. Not to talk about feet. And here, my lord, I appear. And there, my lord, the authorities are, my lord, withhold. And their objection, I'll read out. Then I'll come to the authority, my lord. I'll take 2 minutes. Their objection, I'm reading out, my lord. This is some language correction possibly is needed, my lord. Otherwise, just reading this way, my lord, my goodness gracious, as if we have committed some fraud. It may not be there with your lordships, my lord. I'm reading it and placing it before you. No, the start of 90. Objection of, my lord, by the Central Bureau of Investigation, my lord. Page 150, my lord.
150.
150, my lord. 12 to 4, no? Lordship may have found, my lord.
In this bill 9, something.
Lordship may. I'm reading it and placing it before your lordships, my lord.
It's not here actually.
Can it be at 2 or should I read it or place it before your lordship?
Yes.
My lord, that affidavit may have come, my lord.
Yes.
There, my lord, I'll be very, very careful. I have taken time, my lord, with all respect, my lord. There, what has happened, my lord? Kindly see, my lord. But I'll not be reading much, my lord. Page 150. There are 12, my lord.
Yes.
Also may have found, my lord. The content of Vera 4 is false and misleading. This is the language, my lord. I will not go beyond it. And is denied. The petitioner was examined pursuant to a section 35 BNSS notice dated 3/12/25 after rejection of the bail order, my lord, pre-arrest bail, but remain evasive and non-cooperative, necessitating his arrest. In the interest of effective investigation, the allegation of mechanical arrest is wholly unfounded. I'll be 1 minute, my lord. Article 23, my lord. Article 23, my lord. Just for a reference, my lord. How can they write central government agency, my lord? False and misleading, my lord. This is a constitutional mandate, 23, my lord. No person accused of any offense shall be compelled to be a witness against himself. This is a constitutional mandate, and they say this is false and misleading, my lord. And thereafter, kindly see. 7 is incomplete, my lord, because demand and acceptance. My lord, the acceptance is gone, my lord. That 13. Content of para 5 is misleading. Though a search sheet has been filed, the investigation is at a crucial and sensitive stage. Very good. CFSL report relating to voice spectrography and handwriting analysis, along with examination of material witnesses, are awaited. Very good. Kindly see this line. Further investigation is indispensable to establish demand, meaning thereby demand has not been established. Motive, they will find out. An acceptance of bribe. I was taken to 29 days in custody, 5 days in police custody. Thereafter, in judicial custody, no further investigation. My office have been frozen, my lord. With all respect, I'll not go. All like this, my lord. And language is, my lord, it tantamounts to my lord. I should not say much more than that, my lord. If you, I'll be very limited, my lord. That demand and acceptance both are a must, my lord. It was referred to a 5 judges bench, if I'm not mistaken, my lord. And Neeraj Datta, my lord. Then it came in 23, my lord. The relevant line. The reference has been answered in this manner, my lord, with all respect, my lord. With what emerge, I'm sorry. Para 88, my lord. Paragraph 88, my lord. I need not read, my lord. That not necessary, my lord. That both are a must, my lord. Then again, it is furthermore reiterated in another authority of the apex court, my lord. Again, 2019, my lord. D. Sohan, my lord. There, my lord, also paragraph 32. Where it will be one-liner, my lord. Since in order to attack the rigors of section 3, 13.2, both, my lord. Since, para 32. Since in order to attack the rigors of section 7, 13.2, read with section 13, so and so, so and so. Even as regards 13, my lord, disproportionate asset and or whatever be it, my lord. The prosecution was under a legal obligation to prove the twin requirements of demand and acceptance of bribe money by the accused. The proving of one alone, but not the other, was not sufficient. One is already gone, my lord. This is, my lord. And thereafter, my lord.
This is you are reading from Santosh.
No,
from
not
Dasrat.
Alian, Dasrat, my lord. Para 32.
Para 32, yes.
Para 32, Dasrat, my lord. Para 32, my lord. Yes, Santosh, my lord, I am reading. Because of that, my lord, that I did not cooperate. Para 6. Para 6, my lord. I'll kindly see one part, my lord. The Article 23 enjoys an exalted status. The provision is an essential safeguard in criminal procedure and also meant to be a vital safeguard against torture and other coercive method used by the investigating authorities. Therefore, merely because the appellants did not confess, exactly, my lord, I am to say that I arranged the money. It cannot be said that the appellant was not cooperating with the investigation. Secondly, my lord, notice came, I went, there is a rider, my lord. However, in case there is no cooperation on the part of the appellant for the completion of investigation, it will be certainly be open to the respondent to seek for cancellation of bail. That would be upon someone if I don't appear. Have I made my position clear, my lord? 35 notice was given. After cancellation of bail, my lord, I immediately appeared, my lord. So absolutely, my lord, 23, my lord, disrespect to it, my lord. And parity I should not give, my lord. That is not necessary, my lord. The right giver has been granted the privilege of bail, my lord. This much, my lord.
Yes.
Yeah, please, your lordship. First of all, to start with, the FIR was registered on 14/10/25, your lordship.
Yes.
And on that particular day, as my learned friend said, that IO has went to the premises for the search and he was available. On that particular day, of course, IO has went there to their premises, to the firm for search and seizure, but not necessarily that on that particular date it is required to be arrested. With regard to that, he was not cooperating. To that effect, my learned friend said that he is cooperating because on 14/10/25, FIR registered at that point of time. This IO went there for search and seizure. But at that point of time, there is not necessarily that on that particular date, he will arrest. So question of saying that he is not absconding does not arise here at all, because subsequently when the phone calls were made, the phone was found switched off, office was closed in Calcutta, consequent upon which it has to be sealed. House and office is required to be sealed because his another house is at Berhampur. So his residence is Berhampur, office is at Calcutta, that firm. And when he was not available, at that point of time, his office as well as residential premises, which is at Kolkata also, that has been sealed by the IO. There is no dispute to that effect. And moreover, during the search, they have seized one mobile phone that is make of Samsung. However, during the course of investigation, when they have taken the CDR, call detail. So when the call detail was taken, it is already in this CD. Everything is there. To that I am giving a submission to your lordship. Call detail has been obtained from 1/1/25 to 14/10/25. So this call detail is with them that reflects the unique number IMEI of iPhone. Whereas on seizure, one Samsung phone has been seized. So the person has very, we can say mischievously or tacitly has changed the mobile and he has already destroyed this iPhone. Call detail, because IME is a unique number. And during the course of investigation, when the CDR has obtained from 1/1/25 to 14/10/25, it was pertains to iPhone. Because after seizing the Samsung mobile phone, when they tried to match the number, two different number was found. This one is recent and iPhone was destroyed. So thereby he tried to conceal the evidences or destroy the evidences. This is most important part, consequent upon which the IO could not able to thoroughly investigate the matter. Moreover, call details are there, conversations are recorded, that has been sent for forensic. And during the course of investigation, one diary has been seized from the premises of the public servant. That I have given in my reply also, Your Lordship. That is in paragraph number 19, page number 152. Content of paragraph number so and so are denied. The trap proceeding on 14/10/25, recovery of 10 lakhs from the office drawer of Sri Maisnam Riten Kumar Singh and seizure of a spiral diary recording bribe collection, including 10 lakhs from Mohan Lal Jain. It is a firm's name, and Amit Jain is one of the partner. Mohan Lal Jain established demand and acceptance of illegal gratification. So far the question of acceptance and demand, these are the matter of trial, and this can be argued at the time of this charge hearing. Now my learned friend has said there was no shadow witnesses. This is very pertinent and it is a crucial thing. This, why shadow witnesses is not there, it is not arising out of any complaint. This is a collusive with the firm and the public servant. So question of shadow witness does not arise. When shadow witness is there, when the complainant is there, and complainant used to give the bribe amount, and thereby by way of chemical it has been get washed and the color will get different. So it is not as, so shadow witness is not required. This trap is out of the collusive. This is a collusive nature. The question of shadow witness does not arise at all. Moreover, the question of attracting section 7 at this stage, does not arise. Moreover, after the amendment of the PC Act, private firm, commercial organization have been also included in the parameter of the PC. Section 7 speaks offense relating to public servant being bribed, obtains or accept or attempt to obtain. So direct accepting when it is of collusive nature, no complaint. So direct accepting and demand, that will never come. Any conspiracy is always hedged in hidden way. It cannot be open. And moreover, it is reflected from the diary and the call detail, voice sample is there, voice recording is also there. So section 7 speaks about obtains or accepts or attempt to obtain. Here what happened? They are being followed by the investigating agency when they have come to know this type of corruption is going on. While following, the investigating agency has already seen that somebody is carrying the packet containing some amount. After going inside the room of the public servant, when he came out, they have caught him. He has said, yes, I gave 10 lakhs of rupees that is available in the drawer, and Binod Jain, he led them where it is available. The polythene packet has already been seized. The polythene packet in which the money has been carried, that has already been seized, and to that effect, evidence of the investigating agency and other witnesses are there. So the question of that red-handed, why it is not red-handed? Because it is collusive, so complainant is not there. Neither the acceptor is complainant nor the giver is complainant. So the question of having a shadow witness does not arise at all. That apart, your lordship. After this 14-10-25, thereafter seizure of from the office, IO tried to contact them. He has switched off. Accused person has switched off his mobile, and they have already informed to the staff of the official. Even then, he never contacted. Consequent upon which, he has immediately filed on the arrest of the Binod Jain. He has filed anticipatory bail. That was rejected, and thereafter he has surrendered, or IU has arrested. So right from the beginning, he is avoiding. Moreover, he is the partner, and Mr. Binod Jain has specifically admitted that this amount is given by my so-and-so, and I have to hand over him. To that effect, my learned friend has already read the conversation. I don't want to read out, it is already there. Now I am coming to the charge sheet, your lordship. At page number 51. Second paragraph, your lordship.
Is number 50?
51. 50. Further, on 14-10-25, a trap was meticulously staged to apprehend the accused, Sri Maisnam Riten Kumar Singh and Sri Binod Kumar Jain. He is the manager. And he was released on the ground that he was suffering from liver disease, liver cirrhosis. It was already observed there in the order of the bail application, order of the bail application. Binod Jain, in the act of the transacting the bribe of rupees 10 lakhs at the office of the former, at approximately 11:30 a.m., Sri Binod Kumar Jain arrived at regional office NHIDCL and handed over rupees 10 lakhs contained in a black carrying bag. This black carrying bag is already seized. To Sri Maisnam Riten Kumar Singh, immediately thereafter Sri Binod Kumar Jain exited the office chamber and was apprehended by the CBI team. Upon questioning in the presence of independent witness, Sri Binod Kumar Jain unequivocally admitted to have delivered the bribe of rupees 10 lakh to Sri Maisnam Riten Kumar Singh. Following the specific revelation by Sri Binod Kumar Jain, the CBI team at his indication and in the presence of independent witness recovered the entire bribe amount of rupees 10 lakhs. So there is no two version. IO is relying on this version because it is in a collusive nature. Having a shadow witness does not required. 10 lakhs from the drawer of the office of Sri Maisnam Riten Kumar Singh. The recovered sum comprising 20 bundles of rupees 500 currency note was found in the same black carrying bag that Sri Binod Kumar Jain had brought to the office. The amount was counted and verified in the presence of the independent witness, confirming the total sum of rupees 10 lakhs. The entire amount was seized and taken into the official custody by CBI. Now I am coming to the 53, last paragraph. These are relevant which I am coming. Subsequent to their arrest, searches under Section 185 BNSS Act were conducted by CBI on 14-10-25 at the residential and office premises of the arrested accused, the Maisnam Riten Kumar Singh and Sri Binod Kumar Jain, as well as the premises of the another FIR named accused, Sri Amit Kumar Jain. During the conduct of the searches at the residence premises of the accused Maisnam Riten Kumar Singh at Guwahati and Ghaziabad, Uttar Pradesh, as well as office premises, a total amount of rupees 2 crore 62 lakhs 56,500 was recovered from the Maisnam Riten Kumar Singh. In addition to incriminating document and other assets, all of which were seized by the investigating team. Now, at page 53, second paragraph. Substantial material evidence have been collected during the investigation which indicate that Amit Jain and Vinod Jain are involved in criminal conspiracy with Mr. M. Riten Kumar Singh. And there
Which
is
paragraph reading?
53, second paragraph of the charge sheet. Substantial material evidence have been collected during investigation which
Page
indicate
53.
page 53 of their petition.
Yes. Second para is during the course of investigation.
Page 53, they have given me, no, there is no. Page 53.
I think there are two.
Oh,
page
there are
53.
two page 53 you have made. Pagination theoloker sir.
So we'll take it as 2 page.
Second 53, let's see. Substantial material evidence have been collected during the investigation, which indicate that Amit Jain and Vinod Jain are involved in criminal conspiracy with M. Riten Kumar Singh, and there is a deliberate payment of bribe of rupees 10 lakhs to secure extension of time. That is a admitted position that work is not completed and they need the extension of time. 10 lakhs for extension of time and completion certificate for the project. A recorded conversation dated 23/9/25 between Amit Jain and Vinod Jain establishes that Vinod Jain informed Amit Jain that rupees 10 lakh was to be delivered to Mr. M. Riten Kumar Singh, and only after his approval the bribe was paid by Vinod Kumar Jain to M. Riten Kumar Singh. Amit Jain was the main beneficiary of the entire bribe transaction by way of getting extension of time of a delayed project. The voices of Vinod Jain, Amit Jain, M. Riten Kumar have been identified by Binayak Kumar, General Manager HIDCL Regional Office Guwahati, who was working with them on 9/12/25 in the presence of independent witnesses. Searches and simultaneous seizure have revealed that the accused M. Riten Kumar Singh maintained a record of bribe collection in a diary. That is also seized, which has been seized from the exclusive possession. The diary mentions of undue advantage between M. Riten Kumar Singh and Amit Jain, partner Vinod Kumar Jain, representative of MS Mohanlal Jain. MS Mohanlal Jain is the name of the firm. The accused firm in the month of October 25. Now I am coming to page 54, your lordship. First paragraph, during the investigation, a black spiral bound board premium notebook comprising 240 pages and belong to accused M. Riten Kumar Singh, Executive Director, Project NHIDCL, Regional Office, Guwahati, was seized under Memorandum of Recovery and seized dated 14/10/25 on page 183 notebook under the heading October 25. Entire entries were recorded as follows. 1. MKC 7.5, 2. Anil Das 16.0, 3. Regal 1.35, and 4. ML Jain. So in his diary, it is already indicated.
But can you use that diary against Amit Jain? Jain diaries, Advani.
Gone, my lord.
Jain house.
Jain diary, gone, my lord. Exactly.
But this is recovered from the position of the public servant.
This is what? Amit
And
Jain is not the
it
public
has to-
servant.
It has to be
This is the public
corroborated by
record.
the conversation, CDR, call detail. Your Lordship.
Anyway, yes, yes. Go on.
That is the question of trial. And these notation indicate that the accused meticulously documented bribe amount received from the various individual, including rupees 10 lakh from Sri Vinod Kumar Jain, representing MS Mohanlal Jain. So firm has already been indicated where the project are there, ML Jain's firm. corroborating the illegal gratification received in connection with the Dimau-Moran highway project. In the course of investigation, recorded conversation between Sri M. Ritin Kumar Singh and Sri Binod Kumar Jain and Sri Amit Jain conducted on various dates. These are the dates when the call detail has been taken and were collected and transcript were prepared in the presence of the independent witnesses. Analysis of this conversation reveals critical insight into the modus operandi of the accused, in particular, recorded exchanges dated 17/9/25, 22/9/25, and 25/9/25 between M. Ritin Kumar Singh and Binod Kumar Jain indicate that Sri Ritin Kumar Singh repeatedly pressurized Binod Kumar Jain to meet him in person, including during late hours. In conversation dated 23/9/25 between Sri Amit Jain and Sri Binod Kumar Jain, Sri Binod Kumar Jain stated, "उसका फोन आया था, उसका 10 देने का है." When asked by Sri Amit Jain, "किसको?" To whom? Sri Binod Kumar Jain replied, "Kumar ko."
Means Amit Kumar did not even know whom bribe was to be paid. He asked Kisko. That means he didn't know anything.
So he is asking his manager.
This is
"किसको
my
देना?"
favor, my lord. I read it out, my lord.
It's a question of interpretation, Lordship.
No, it's not a question of interest.
And the matter of trial. Kisko means when the
Unless he
Binod-
pays rupees 10 lakhs to 100 people every day, then asking Kisko would be justified.
in this context and out of context, I am submitting your lordship. Kisko, when my manager is there, definitely my business is going on. And if my manager is asking me some amount, definitely I will ask him, Kisko. This is implied thing because he is my manager. Maybe out of context, your lordship. Kumarko, this communication strongly indicated that the matter related to the issuance of completion certificate and grant of extension of time were pending with Sri Ritin Kumar Singh, and that he was exerting undue pressure on Sri Binod Kumar Jain for personal meeting. Further, the conversation between Sri Amit Jain and Sri Binod Kumar Jain implies that a bribe of rupees 10 lakhs had been agreed upon and was to be delivered to Sri Ritin Kumar Singh. Now, in the second paragraph, that is with regard to the voice identification, your lordship. During the course of investigation, the voices of M. Ritin Kumar Singh, Amit Jain and Binod Jain have been identified by an official of NHIDCL. Regional Office, Guwahati. Further, the specimen voices of the accused person, namely Sri Binod Kumar Jain, Amit Jain, and M. Ritin Kumar Singh, were collected in the presence of independent witnesses under Panchanama. The said sample voices, together with recorded questioned voices containing incriminating conversation between the accused person, were sent to CFSL, Assam, for voice spectrography testing report from CFSL is awaited. So at the time of filing of these charges, this was awaited. And at the time of filing the charges, the IO has already taken a leave to give a supplementary charge sheet, reason being, during the course of investigation, certain new thing has revealed, larger conspiracy has been revealed. And while doing so, they have come to know with regard to still the investigation is going on, which the contract of this person has been taken. And during that investigation, new thing has revealed about Dimau and Moran to Bogibil Junction. That is still under investigation. So this is the part of the larger conspiracy. And if at this stage, if he is allowed to remain allowed, his application is allowed in that event, he is a resourceful person.
No, but your this 10 lakh is connected only to this Dimau project.
Dimau project.
There is something for some other project, that would be a different
maybe-
case.
No, but the contract is one and the same. Transaction is one and the same. If it is arising out of the same contract and same transaction, that is why leave has been taken to file a supplementary charge sheet. Charge sheet has been filed after 60 days. That is within a period of statutory
Contract is
period.
for which work? As far as this petitioner is concerned, or rather his firm,
Yes, your lordship.
contract is in respect of which work?
My lord, this is absolutely 123, page 123, Dimau, my lord.
Demo.
Imo Moran.
All these are connected one, and in the project detail, it has been,
Project may be connected, but unless he is a contractor for the other project, then where would his involvement come in for the other project?
he is, that is why this prayer has been given that the IO will file a supplementary charge sheet, and within a period of 60 days, they have filed this charge sheet, taking the leave from the trial court. Because during
Yes,
the
go on.
course of investigation, a larger conspiracy has revealed, and these are all the documented thing, it requires some time. And moreover, they are the influential person, big shots, and they are always in the contract business, and there is every possibility that there is some traces of money trail that will be revealed from the diary which they have seized. And the moment he has been released, definitely there is every likelihood they will not only influence the witnesses, but tampering of the document will be there. They will
What to the
destroy
evidence?
because phone, they have already destroyed iPhone. And this was the subsequent phone. When the call detail has been taken, that in respect of 1125 to 141025, that is in respect of iPhone. That CDR detail is specifically showing the IMEI unique number. And while seizing the phone from their office, that is a Samsung make, and IMEI is not matching with this call detail CDR. And the IO cannot lie because these are the matter of forensic. It is not matching. That was iPhone. It is indicated there. And he has destroyed, already destroyed, because it is containing many incriminating things. Many details are there. So one evidence he has already destroyed. Coming to yes, charge sheet page 52, they have already, and the order with regard to the bail application of Binod Jain, who is the manager. To that effect, it is he was suffering from liver cirrhosis.
Age?
I'm coming to that, Your Honor. You know, application. I'm coming to that, Your Honor. Just now, my learned brother has already gone through that order.
Page 101.
Yes, Your Honor. So page 101.
Bail ground was taken, but on merit bail has been granted, my lord.
That is.
Para
but-
18, my lord.
But during the course of argument, insistence was given to the medical ground because he was suffering from liver cirrhosis.
Assistance may be given by the council. What matters is what?
Yes, and it is.
The ratio would go, my lord, the obiter would not go.
It is seen from the medical document submitted by the accused applicant that the accused applicant is suffering from chronic health element which may aggravate if timely special medical attention is not given to the accused applicant. This is also observation given by this honorable court.
Next paragraph, please read the next paragraph.
Yes, it is there. Taking into account the whole factual matrix, material available before this court, including the material case diary made available.
All right, we have
to
gone
this
through
court.
that anyway.
The
Continue.
case diary is also here, and today the case diary will reflect the progress of the case. Apart from that, I have already marked in the case diary, your lordship, in the relevant portion, which is for your lordship convenient, though several marking are there, but specifically which is relevant here is all yellow one, which will say with regard to the iPhone 16 Pro.
Yes.
It is during the CDR call detail for mobile number so and so, which was used by Amit Jain. It was observed that the mobile handset in which the SIM card for the number was used until 14/10/25 at 9 22 PM was different from the mobile handset that was seized during the search conducted at residence of Amit Jain on 14/10/25 at 10:30 PM onward. The IMEI of the mobile used until 14/10/25 at 19:22 is so and so number, which correspond to the Apple iPhone 16 Pro. In contrast, the IMEI of the mobile phone seized from the accused number so and so and so and so connected with Samsung Galaxy 16. So this is shows his conduct that.
No, I am trying to understand what difference does it make once you have got the call detail reports connected to the phone number of the accused, whether it is from the iPhone or whether it is from the Samsung phone. I am trying to understand what is the difference.
Phone has its own memory. It contains different datas and details.
That's a different
It
issue.
is destroyed.
All details are with you.
All details are with us. Other datas are there because it has memory. Mail and other details are there. WhatsApp chat is there. Everything is there. Nowadays, iPhone contain lot of configuration. It contain many features. So that has been destroyed.
And he refuses to give the password, what would have happened? Can you force him?
But that is also the fundamental duty to cooperate the IO.
That may amount to self-incrimination.
Beg your lordship.
That may be protected by Article 20 Clause 3.
They will be protected, but at the time of when it is a material witness, seizure. So that will give a clue for the larger conspiracy. At least some certain larger conspiracy is there because this economic offenses is impacting the society. It is a societal effect is there, always there.
Yes, understood.
Now I'm coming to the judgment, your lordship. वैसे ही दीजिएगा सीरियल में in serial I am giving your lordship all the judgment with regard to the दे दीजिए पहले This is the first judgment with regard to the recent one, serious fraud and investigation at page number 36, your lordship. At page number 36, just as a liberty is precious for individuals, so is the interest of the society in maintaining the law and order. Both are extremely important for the survival of civilized society. Sometime in the larger interest of the public and state, it becomes absolutely imperative to curtail the freedom of an individual for certain period only, then non-bailable warrant should be issued. Then I am coming to 18, that all the judgment I have given serially.
Yes.
Then I am coming to page number 36. 37, that is reflection of P. Chidambaram case is also there and the judgment has also been given there.
Yes, Aditya Sarda. Aditya Sarda.
Aditya Sarda. There are page number 36.
Yes, you have mentioned that page number.
I have already mentioned in the first page all the numbers. And thereafter, I am coming to Devendra Kumar Bansal. This is also latest one at para 22, page 10. Para 22 at page 10. In the aforesaid context, we may refer to a pronouncement in Central Bureau of Investigation versus Vijay Sai Reddy reported on so and While granting bail, the court has to keep in mind the nature of accusation, the nature of evidence in support thereof, the severity of the punishment which conviction will entail, the character of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witnesses being tampered with the larger interest of the public estate and their similar consideration. It is also to be kept in mind that for the purpose of granting bail, the legislature has used the word reasonable ground for believing instead of the evidence, which means the court dealing with the grant of bail can only satisfy it as whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. It is not expected at this stage to have the evidence establishing the guilt of the accused beyond reasonable doubt. At para 27, page 12. That is in Manoj Narula versus Union of India. That is also Supreme Court. This court held that the corruption erodes the fundamental tenets of the rule of law and quoted with approval its judgment in Natarajan Hemchandra Sasital versus State of Maharashtra. It can be stated without any fear of the contradiction that the corruption is not to be judged by the degree. For corruption, mothers, disorder, destroy, societal will be progress. Accelerate undeserved ambition, kills the conscience, jettison the glory of the institution, paralyze the economic health of the country, erodes the sense of the civility and mars of the marrow of the governance. My learned friend had said that in 2G and Hawala cases, there is 1,000 crores of rupees. To that effect, this is there. It does not judge with regard to the amount of the money. Any corruption cannot be judged by the way of amount of the money. To that effect, the Supreme Court has already clarified. And there are another, in page 29, paragraph number 2913, that is also relevant with this regard. Then I am coming to our own judgment that is given by this honorable court in Puspajit Purkayastha versus Central Bureau of Investigation. This is of our own honorable court's judgment at page number para 20, 31, 32.
What's the name?
I'm coming to 31, page number, last but once, page number 6, Your Lordship. Para
This
31.
is a repetition of what you have said earlier,
Yes,
CBI
yes.
versus Vijay Sai Reddy.
Vijay Sai Reddy and this one. And again, YS Jagan Mohan Reddy. This is the repetition. Now coming to Tarun Kumar's Assistant Directorate of Enforcement. Page 22. And this is also having the reference of Y. Jagan Mohan Reddy and Central Bureau of Investigation at para 22. Lastly, it may be noted that as held in the Catena of decision, the economic offenses constitute a class apart and need to be visited with different approach in the matter of bail. The economic offenses having deep-rooted conspiracy and involving a huge loss of public fund need to be viewed seriously and considered as a grave offenses affecting the economy of the country as a whole, thereby posing serious threat to the financial health of the country. Undoubtedly, economic offenses have serious repercussions on the development of the country as a whole. To cite a few judgments of this regard, YS Jagan Mohan Reddy and Central Bureau of Investigation, and another one is Nima Gadda Prasad versus Central Bureau of Investigation. Then Amit Kumar is also there. It has been referred here. This court taking a serious note with regard to the economic offenses and had absorbed as back as in 1987 in case of Gujarat versus Mohanlal, Jeetmalji Power and other. So the para is quoted here. The entire community is aggrieved if the economic offenders who ruin the economy of the state are not brought to the book. A murder may be committed in a heat of moment upon the passion being aroused. An economic offense is committed with a cool, calculated and deliberate design with an eye of personal profit regardless of the consequence of the community. a disregard for the interest of the community can be manifested only at the cost of forfeiting the trust and faith of the community in the system to administer the justice in the even-handed manner without fear of the criticism from the quarters which view white-collar crimes with a permissive eye, unmindful of the damage done to the national economy and national interest. And thereafter, this is Chidambaram has already been referred, and I have already given the page number, your lordship, at page 25, para 79. That is the relevant one. Page 25, para 78. That is the repetition that the entire community is aggrieved with this. If the economic offenders who ruin the economy of the state are not brought to book. This is the repetition of another one. So Supreme Court has repeatedly reminded this economic offenses. Then Satindra Walia and serious fraud and investigation. This is at page number 8. Para 37. Honorable Supreme Court in serious fraud and investigating officer and Nitin Johari, wherein set aside the order of the High Court of Delhi granting bail to the accused therein and held that it is necessary to advert to the principle governing the grant of bail under section 439 of the CRPC. Specifically, heed must be paid to the stringent view taken by this court towards the grant of bail with respect to the economic offenses. This is given in the Satindra Walia. So repetition is there, and another one is also Hilal Ahmad. Of course, it is of the High Court of the Jammu and Kashmir. These are the conditions wherein it is given in from paragraph number 12. While granting the bail, what are the factors to be taken into account? This is in paragraph number 12. These are the factors before considering the rival contention of the parties. Let us discuss the legal position governing the matter pertaining to grant or refusal of bail. This is from paragraph number 12, having A, B, C, D, and thereafter 13. So I have given the page number in the first page. This is of the High Court. So at this stage, my humble submission, since the further investigation is going on, unfold the truth of larger conspiracy, and CDR detail is also there, voice sample is also there, and some forensic reports are still awaited. So at this stage, if the bail is
How can he influence those? Voice spectrography, handwriting analysis,
Yes,
all those things.
voice spectrography, handwriting.
These are within your control. But you have stated in your counter,
Yes,
that is why I'm saying.
It is in paragraph number 30. Though the charge sheet has been filed, the investigation is yet a crucial and sensitive stage. CFSL report relating to voice spectrography and handwriting analysis, along with the examination of material witness, still material witnesses are not being examined. It is pending, are awaited. Further investigation is indispensable to establish the demand motive and acceptance of bribe.
And that is a vague term, examination of material witnesses. That may continue forever.
No, that is because it is arising out of the same tender, same transaction, and certain other transaction is also there, which has revealed from the diary. So at this stage, my humble submission, reject the bail application.
FSL report regarding voice spectrography, handwriting analysis, etc., those are beyond the control of the petitioner. He cannot influence that. Can he? Regard to material witnesses.
The moment this report will come, the IO will further start the investigation if something incriminating has come. That is there. From the report, it will reflect. The source is that for further investigation.
So you're relying on further investigation. At present, other than the telephonic voice conversation where he asked Kisko, any other material is there?
The investigation is going on. We have to examine the other witnesses also in this respect, because this is not a transaction of a tender of a very small amount. This is with regard to the NEHAI and the National Highway
We
Construction.
are just trying to apprise ourselves about the specific material available against him as of date. So anyway, go on.
My lord, I'll take a minute, my lord. Only one thing, my lord, they want to cloud it, make the situation further nebulous. The larger conspiracy is, my lord, as I have understood, my lord, because it is in black and white. Beautiful English will not be sufficient, my lord. Can you see? Only 60% work is left. Subject matter of this case. If he has defalcated money in some other project, that would be different affairs, my lord. Here, kindly, one thing is absolutely what she is saying is not in consonance with facts, my lord. That occurs at page with 88% there. Only 60% remains. I'll be only 1 minute I'm taking, my lord. Here, my lord, with all respect, my lord, let us have a conjoint reading, page 123, including the learned public prosecutor of the CB 123. How much work is left? Larger conspiracy can be to the extent of remaining 60%. Page 123, GM Dibrugarh informed that progress of the project is 99.40%, meaning thereby 0.60% remains. So larger conspiracy can be to the extent of only that 0.60%. Have I made my position clear, my lord? And disproportionate asset of the bribe taker, that would otherwise it would cloud my case would be clouded, my lord. It would be nebulous. Page, with all respect, my lord, page 53. Page 53, my lord. This is regarding that 2 crore something she said. It is not subject matter of this case is only 10 lakhs, my lord. How he amassed that amount of money, page 53. Based on the available evidence, CBI SCB Guwahati has registered another case bearing numbers, another case, not this case, my lord. Have I made my position clear, my lord? PC Act against Maniram Riten Kumar Sim, the bribe taker, on allegation of intentionally enriching himself illicitly by acquiring assets to the tune of 2 crore something. With this 2 crore, I have got nothing to do with it, my lord. Subject matter of this case is 10 lakhs, that is recovered, my lord. So larger conspiracy is to the extent of 0.60% unfinished. This pertains to retaining disproportionate asset. That too, a case under section 613, different case, my lord. Subject matter of not this case. No larger conspiracy, my lord. And thereafter, my lord, assuming, not admitting, my lord, we have provided all the mobiles, assuming we have destroyed a mobile, what section of law would be attracted? It is there in the statute, my lord. They cannot go beyond the statutory provisions. BNS should be applicable even to the CBI. 238 would be applicable, my lord. Causing disappearance of evidence of offense or giving false information. I fall in the first category, causing disappearance of evidence. Assuming I have done it. I have not done it, my lord. And it's a bailable offense. And there the quantum of punishment provided is, my lord, with all respect, my lord, 7 years, but it's bailable, my lord. Bailable offense, my lord. It goes like that, my lord, with all respect, my lord. And another thing, my lord, that I was absconding, a man who seeks, my lord, statutory provision. I avail of the opportunity of agitating before your lordship, earlier section 438, my lord. That would be not absconding, my lord. As they have repeatedly, they have been stating, my lord. With all respect, my lord, they have been, as they have been stating, my lord. And my lord, another aspect she is stressing on, which is contrary to truth, my lord. The bribe giver, with all respect, my lord, medical gown was not that was the obiter, my lord, not the ratio. Ratio of that order is at para 18, my lord. I will not read it, my lord. It will take your lordship's time. Taking into account the whole factual matrix, materials available before this court, including the materials in the case diary, bail has been granted. Have I made my position clear? And the material is this, that, with all respect, my lord, caught red-handed, same investigating officer, and he was loitering in the premises, my lord. Meaning thereby, it is contrary to the apex court full bench authority, 5 judges bench authority, my lord. Article 141 will prevail, my lord. The law laid down by the Supreme Court shall be applicable to all courts throughout the territory of India. That she is negating, my lord. That cannot happen because now in their affidavit they are saying, my lord, that I am reading out, my lord. Till now, they have nothing in their hands regarding except the demand and acceptance, my lord, with all respect. because they are black and white, my lord. Can they erase it? 13, my lord, page 151, my lord. Contents of para 5 is misleading. This is their language, my lord. Though a charge sheet has been filed, the investigation is at a crucial sensitive stage. CFSL reports relating to voice spectrography and handwriting analysis along with examination of material witnesses are awaited. Good enough. If I come out on bail, how do I be thwarting them? I do not know. But this line is most important, my lord. Further investigation is indispensable to establish, meaning thereby prima facie, ex facie, till now they have not established all the sections of law, my lord, is indispensable to establish demand. Demand has not been established, motive has not been established, and acceptance of right has not been established, and 29 days I am in custody. Co-accused is on bail, the bride give her, my lord. With all respect and folded hands, my lord. I appeared voluntarily, my lord. With all respect, this is my case, my lord.
To motive demand. The matter to be taken in the trial court here. Is we have to go back.
Let her give a judgment, my lord. That authority she does not have, my lord. Let it be there in a pronouncement of a court of law, either of this High Court or by the apex court, my lord.
Given the number of judgment in the Supreme.
Can you show me that line, my lord? This is in their objection in black and white, my lord. With all respect and folded hands, my lord. Public.
Much of it.
Please, the Lordship.
CD, Lordship, CD, I said something.
Submit the CD.
And all yellow marking is done by me for the relevant portion.
That page 11 is the affair, my lord. It's a regular bail application, my lord. That in this case, my lord, there was an exchange of words, my lord, between the, my lord, elected members of Anchalik Panchayat and the BDO, my lord, and the complainant himself is the, my lord, member of, my lord, rival party, my lord. And I am none of the accused, my lord. There is no specific allegation against me. I'm a school teacher, my lord. And regarding the, my lord, all other accused persons, my lord, all of them have been released on bail, my lord. I may be allowed to produce the, my lord, bail orders, my lord. Recently, my lord. Yes. Yes. Including one, my lord, who was also arrested. One of the accused was Rafiqul Islam. He is, my lord, the accused number 9, my lord, in the affair, my lord. There are two bail applications, my lord. One was preferred jointly by 7 number of accused, and another was, my lord, bail application case number 1864. That is in respect of Rafiqul Islam, who was arrested, my lord, on 3rd of, my lord, December, my lord. And the other bail application 1868, my lord, there are altogether, my lord, 8 accused persons, my lord. All of them have been released on bail. I'm a school teacher, my lord. The only thing is that, my lord, the accused number 1, my lord, is Saddam Hussein, my lord. He is related to me, my lord. He's my brother-in-law, my lord. And on the day of alleged incident, my lord, I was discharging, my lord, duty in my school. I'm referring to, my lord, page 19, my lord, annexure 4, my lord. Lord, you will kindly see for a moment, my lord. Annexure 4, page 19, page 20 is the vernacular, my lord. The original, my lord, certificate, my lord. On the day of alleged incident, he was discharging, my lord, his duty in the school, my lord, for the whole day long, my lord. He doesn't know anything, my lord, regarding the incident, my lord. And there is no allegation against him. He is not a named accused defendant, my lord. And all the other persons, my lord, have been released on bail. Nobody sustained any injury, my lord. There was no injury, my lord. Only, my lord, scuffle and exchange of force.
Yes, they received, my lord. As per allegation, 4 persons, my lord, were injured. Pranjal Kolita and Fariduddin Ahmed and Akhtar Hussain. But in the case, there is no injury report available right now, my lord. And regarding only statement of those injured persons available, and those injured persons implicated the present petitioner.
Nature of the injury?
Yes, my lord.
Nature of the injuries?
Nature of the injury, my lord, only as per allegation grievous, but injury report is not available.
My lord, I'm referring to, my lord, this bail applications, my lord, second page, my lord, bail application 1868, my lord. 1868, my lord.
Yes.
Same paragraph, my lord. In both the petitions, my lord, same paragraphs have been quoted, my lord. The perusal of the case diary and the statements of the witnesses and the alleged victim shows that there was a scuffle which ensued when the complainant and some other members of the BJP Mandal committee went to protest over some anomalies in the office of the Nizding block office. The materials collected by the IO shows that the entire incident took place in the presence of block development officer, but she has not been examined. The BDO was not examined, my lord. In the next page, the complainant and the alleged victim appears to be the ones who had gone when the official meeting was in progress, and there is nothing to show that the accused persons would interfere in the investigation if allowed to go on bail, or they will misuse the liberty of the same. No injuries are found on any person, my lord. This is very specific, my lord. Nothing, my lord. Now she will kindly grant me, my lord, the privilege of bail, my lord. My lord, my detention is itself, my lord, damn illegal, my lord. I was detained on, my lord, on 14th of December, my lord. I'm a school teacher, my lord. I don't know anything about the incident, my lord.
Yes, all right.
I'm deeply obliged. I'm deeply obliged.
I will hand over the case.
Yes.
Deeply obliged.
It is a lordship, my lord, item 66 and 67. Now PP was not there when it was called, so lordship fixed it after some.
Lordship will fix it tomorrow.
Tomorrow, my lord. Deeply okay.
Problem.